Hey guys, and welcome to the weekly docket. Hey guys, good morning. I think I've got it all live now, and let's get started. This is going to be a busy day, of course, because there are a lot of hearings today, even on some of the cases that we're going to be talking about. So we've got to cover some ground before the court does it for us. Fun fact on that intro, I used to custom make that every time I did a weekly docket with pictures about the cases for that day. That was a lot of work. So I think just leaving it as one is better. All right, let's get this bigger and let's go. Good morning, guys. We got comments coming in. Apparently you can hear me. So let's get this party started. And good afternoon to Scotland. I can't not acknowledge that. All right, let's start with Daryl Brooks. He's got a hearing coming up later today, and I'll stream it if it occurs, and I can find it. I think I've got the channel. It's just whether the judge does it. So what's going on? This is the Erica Patterson charges. 2 counts of intimidation, 2 counts of bail jumping. Nobody's jumped bail more than that guy. 2nd-degree reckless endangerment, disorderly conduct, battery, and resisting and obstructing an officer are all the charges he's facing right now. It's really in 2 sets of, it's 2 cases, but they're consolidated at this point. So today is the final pretrial conference, and that's before Judge Havas. I have her picture there. There has been some discussion about, his behavior with this last judge who's a male versus the first judge who was female. Well, we'll see how that goes. He's not, at least looks from the docket, going to have a female judge for the trial if it goes forward on time, because that's been moved over to Michael Hanrahan for August 14th is the trial date. Now, this came up, somebody mentioned it before, and I put a comment with a link in it. The Erica has a YouTube channel, and if you want to see what she thinks about things, no better place to find out than to go to her channel and show it. I mean, I would clip some of that, but that's not fair to her. So check out what she actually has to say. Is she terrified to show up and testify against this guy? She is not. So we've all had a lot of discussion about whether she should have to or not, but she's strong enough to get it done, and she's ready to go. So, and here's Scotland and Ireland. A lot of fun in Ireland I've had, but not in Scotland. I think I've been there. And welcome to Norway. And I know Australia's in the house too. All right, so that's what's going on, right? So he should appear in front of her today, Judge Havas. Erica doesn't have to be there today because it's really just final pretrial conference. It's any final issues we all need to talk about before we head into trial on August 14th. Is somebody going to request a delay? I don't see the state doing that because Erica has said that she's ready to go. Will Brooks pull a shenanigan? I don't know the answer to that either. He kind of did on the last case where he didn't plea bargain, I think at the time that his attorneys thought they would, and you could see the frustration they had, right? So will he do something like that here, or will he pull the big one? Also, hello to Mexico. Will he pull the big one and say, Your Honor, I want to represent myself pro se as a sovereign idiot, and start that ball again? And will the judge entertain it, and what will happen? So I don't know what he's going to do. That's why we're going to watch it. He's a train wreck, always in progress. He was very muted in the last hearing. Will he be that way here? I don't know the answer to that. In theory, they should just plead all this out too, because as the judge said in the last case, it's somewhat academic. But Erica's ready to testify against this guy. So let her have her day in court, I think, if he's gonna continue to say he didn't do these things, and he clearly did. There is a past video I have where I found some of the transcript of the intimidation text, which are pretty hilarious and classic Brooks, because at some point he devises a clever code to disguise talking about himself and Erica, and then when he gets mad, he just abandons it and starts talking about them directly again. So yeah, a real mastermind there. All right, so we will see. And in terms of freeing Erica once and for all, I hear that, but she's ready to come testify. And I think that's awesome of her to stand up like that. And she's acknowledging and thanking people on her channel for supporting her. And in this case, who wouldn't? So, and hello to England. Is the judge able to tell him no? Let me put this up here and read the comment. Is the judge able to tell Darrell no on self-representation? That's possible. He has a right to it, but although people sometimes, it's tough to tell the parameters of that. You can forfeit your bill or waive your rights by the things that you do. So possibly, but I would just have to see at this point. He did bring it up before that he might do it, and then he abandoned that concept. So he's got a right to it. The judge, denying it to this point would largely be based on, hey, you waited too long and it's on the eve of trial, but he kind of did that in his last case. So I don't know. So we will see. I mean, it's possible he has that up his sleeve and he's not even going to say it at this hearing, and he will wait until a few days before trial and then try to make it an issue out of it just to throw chaos. I don't know what he's going to do. But the closer it gets to trial, the more potential the judge might deny it. But, the bias has to be to let him do it because that's his right. But it's not unfettered. It's not like you can never waive that. So let's go. All right. So this happened, which was, I posted this as a document on the YouTube channel, I think yesterday when I saw it. The transcript for his parade attack case is not provided to him yet, and that's been extended to November 18th, 2023. So he needs that to evaluate the appeal, or his attorney does. And the real actual notice of appeal is not filed yet. It'll be filed after he gets the transcript, and he has a period of time after that to do it. So too bad for him. He has to just wait on that. Isn't it a constitutional right for self-representation? Yes, it has been held that. I mean, it doesn't specifically say it, but the court has kind of said if you have a right to have counsel, you have a right to not have counsel. That forcing someone who can make a decision intelligently, I'm using that word loosely, to have a lawyer appointed by the state offends the Constitution. So, yeah, but sometimes you can be found to waive or forfeit your constitutional rights. So that could happen. All right. Here's a question, and maybe other people can answer it. In the initial charging on when it happened, was there any witness to him running her over? Tried to look it up, original. I don't know that. I think it was largely her. And, of course, the injuries she suffered were consistent with that. And nobody's finding this guy not guilty on anything, I think. So if I could take him to court over something, I would, because I would probably win. As long as you didn't depend on getting anything from him, because he's got nothing. Let's go out west, and then we're going to come back to Wisconsin, but talk about Bryan Kohberger. I wanted to have more pictures for this, but the Idaho Cases of Interest site has been going on and off with 503 errors. But unless I missed something, I think I got the points right now. This is one of the less busy cases this week. Aha. Before I hit that, I'll follow up. Tina says there were witnesses and video from the gas station, so there you go. So his ship is always the Titanic. It's always sinking. There's an iceberg everywhere around Daryl Brooks, and he runs into all of them. All right. So the motion to stay is an issue that the state did reply to. Kohberger wants extra time to evaluate challenges to the indictment. And the court found 37 days to be the right number, but then said, but I'm not going to delay the trial yet. I will only do that if you find out you needed 37 days. So the state says, no, don't do that. Kohberger asked for the time, and that's a waiver of a speedy trial for that period. Go ahead and move the trial date out for the time he says he needed or would need to use so that we can schedule witnesses, because right now we have witnesses scheduled for one trial date, but it's highly likely that someone's going to ask for that to be moved out. And now you're saying they can up to 37 days. You're broadening the area where people have to have their lives open in uncertainty. That's a fair point, but welcome to the court system where trial dates are frequently moved. So I thought the judge was trying to split the baby on this, saying I want to hold everybody's feet to the fire, and I'll keep this issue of moving the trial date open till later. But I also see the state's point that this isn't that long in the future, and people ought to have some idea of when they're going to have to come testify to get themselves ready for it and their lives ready for it. But trial dates move, so that's just an issue. Here's a question, does Kohberger have Manson lamps? Now, the first picture of him that I showed, I think is a very fair picture. There he is, just walking. But the one down there where he was talking to the police with his father when he was pulled over after the murders, I got to admit that I chose that picture because of the way he looks in that. So I'm not somebody to say, well, except for Charles Manson mostly, that you can just look at him and see the cold, soulless eyes or whatever and know that they're a serial killer. There are many cold, soulless people who aren't serial killers. So, and sometimes these serial killers are able to cajole their way into and convince somebody to go with them somewhere where they can kill them. So sometimes they can turn the charm on. So I make no judgment on him one way or the other there. The other fight still going on is over the family tree research the FBI did and the DNA analysis they did for that. The state filed an affidavit from the state lab director saying that what the FBI did on that and how they developed their profile, which is a whole different kind of profile to trace family tree stuff as part of their lead generation. That doesn't have anything to do with what we do in our lab, where we do a normal type of STR DNA sample profile, and then we compare it to samples given to us from the state. That's what we do. And that's what we did. And then we give you the results of that. So the family tree stuff has nothing to do with us. And that's the state trying to bolster its argument that the family tree stuff is not exculpatory, since the FBI did say that it was within his family. And they're also not going to use it at trial because they have the actual profile of Kohberger to compare to the DNA that was found on the knife sheath. So they're saying it doesn't have to do with anything, and it's not discoverable. Discovery is not free for everything, and criminal discovery is a little weird. So I could see the judge coming down either way on this, I guess. I don't think it hurts Kohberger if he doesn't get it, but on the other hand, if it possibly could, then he should get it. So this judge seems to like to make pragmatic decisions. If I were guessing, I'd say he gives it to him, but I wouldn't put much money on it either way because I think it's kind of close. Now, there was just some discussion in what they said and what the defense said about the DNA on a sheath being planted. And I think that has just slightly less merit to it than saying sole source DNA on what contained the murder weapon found at the scene of the crime under a murder victim. Just doesn't matter, because that sole source DNA could have come from anywhere in any way. That's not, I think, a reasonable interpretation of that evidence. And now going to the, well, it was planted, is absolutely ludicrous and fact-free and total fantasy. But on the internet, you can find people to believe anything. So why not put it out there? But once you start talking about the evidence was planted, to me, you're running on thin ice there, because implied in that to me is that the evidence is really bad for your client. Because do police want to plant evidence that isn't bad for the person they're trying to convict? Oh, Your Honor, they planted evidence, and we really got to fight to get this planted evidence out. But also the planted evidence, it doesn't matter, right? I mean, it's not important evidence. I don't buy that. To me, it's a little bit like the people trying to say that the cartridge found in the Richard Allen case was planted by the police to frame him, even though what was found on it was not his DNA or his fingerprint, but just some tiny marks made by a firearm that they're saying was his firearm. If you were going to plant evidence, plant better evidence. And normally I would say plant DNA. But here the argument on Kohberger from the innocent side is the DNA just doesn't matter, bro. DNA is not really important because DNA could just come from anywhere. If that's true, then why go down the fantasy realm of maybe it was planted? So yeah, and tiny ninjas riding on the eagle of innocence could have planted this evidence. So I can respect the idea that, you have to go through the logic of, could his DNA been transferred there by somebody else, or could the sheath have been in the possession of somebody else and Kohberger had it previously? Those are reasonable things to think about. It being planted there, say potentially by the police, would be ridiculous. Now, I'm not certain that the defense is going to say that. They may say that we don't know who planted it. It might have been somebody committing the crime trying to frame Kohberger. Well, let's see if there's any evidence of that. I just don't. I think saying things like that to me suggest how you really think your case is. But you only need one dummy. All right, so let's head off to Sarah Boone's case. And that is supposedly going to be heard this morning for a status conference after the farce that was the last conference. Aside from a comment here back on Kohberger, aside from linking him through father's DNA, don't they have his actual DNA to match the blood on the sheath? Yeah, I'm not saying there was blood on the sheath. Okay, I think this was touch DNA. And that's an issue, right? Because some people are like, well, touch DNA can get transferred. And when I talked about this last time, I put a link in the comment to a study that showed how transfers occurs when you have people sequentially handling an item. And in that case, it was a sheath. It was a controlled study. And you can have, person A's DNA may show up on that knife or on another object. So, all right, let me start over again. So person A holds a knife and then stabs something and puts it down. And then person B grabs that knife and stabs something and it touches a plate, and then person C and person D. So this second object sometimes will contain the DNA of person A, even though person A never even touched the second item. But I think one of the issues there is you look at the chart yourself. When that does happen, when person A's DNA is on the second object because they didn't handle it, is it only that person A, or is it a little bit of person A's DNA plus the DNA of the other people who touched or handled that item? And that's where I think this falls down for the defense, is this was sole source DNA on the sheath. It wasn't a mixture of two people or anything else. And the logical explanation for that is you press the button down on the sheath, and when you do that, you leave some DNA on there. So that's my opinion on that. All right, so going back to Sarah Boone here. All right, so waiting on Dr. Bozo was the status at the last status conference where the attorney was on Zoom. He still did not have an expert to testify about battered spouse syndrome or partner syndrome, and wanted that because that's going to be a defense that she tries to apply, which is self-defense. I'm going to show that here in a second. So the judge said, okay, let's do this on July 21st. The call was for 9 o'clock. I don't know if they're doing it now or not, but I'll tell you what I think should happen, and we'll see if that's what happens. And I wrote on this slide, delay inbound. I think that's a safe bet. Of course, this case isn't starting on Monday, period. For one thing, this confidential filing that was made just the other day asked for a motion for appointment of defense psychologist, forensic psychologist, and request for sealed order. So this could be a clown inbound. They may have found somebody who says, yeah, I'll do this. And then the court needs to appoint that person and probably arrange for the fee and stuff like that. And then that person's got to get ready for the case. Is that going to happen over the weekend? I don't think so, but I'll also tell you why, even if that could happen, why it still should be delayed. And that is the second bullet point I have on here, which is the state will also be allowed to have an expert. So in fact, I'll skip this slide and come back to it. Look at this. This is Rule 3.201 in Florida, battered spouse syndrome defense. And a subsection B, the defendant shall give notice of intent to rely on the defense of battered spouse syndrome no later than 30 days prior to trial. Now, he has noticed that, but look what the notice has to contain. A statement of particulars showing the nature of the defense the defendant expects to prove, and the names and addresses of the witnesses they expect to call for that. So if you don't have the expert until today, or when the court orders that, you can't have given a 30-day heads up on who you're going to call, and the state needs to know that, because the state has a right to rebut that with their own expert evidence. Let's go back and talk about this. This is a little clip I put up here is from the Florida bar, and it talks about battered spouse syndrome and how it's applied in Florida. So if you know how battered spouse syndrome is applied in your state, doesn't mean that's how they apply it. In Florida, it's a state-by-state situation, and here's what they say. To justify homicide under a claim of self-defense, the defendant must establish 3 elements: that the defendant believes she must use force against an imminent threat of harm, and that is pretty typical for self-defense everywhere. The amount of force used was proportionate to the threatened harm. The defendant retreated to the greatest degree reasonably possible. Now, you don't have to retreat if you're in your own home, so that's okay. Now, look what they say. Evidence that a woman suffers from battered spouse syndrome addresses part 1 of this standard, whether the woman honestly feared for her life. So you could still have an argument from the state that putting or leaving this guy in a suitcase is not proportional to the threat that he raised. It's arguable or whatever. But she has to show that she believed that she was in imminent threat of harm. So he wasn't attacking her at that point. There's no evidence of that. So battered spouse syndrome is the situation where sometimes the person will take violence against the person who's been abusing them, not at the moment when the person is abusing them. And maybe the person has said, I'll find you wherever you go, I'll kill you, whatever. So it can exist in some cases. I completely agree with that. And that's what the defense expert will talk about to the jury, what the syndrome is, and try and convince the jury that at the time that she left him in the suitcase to die, that she was in fear of imminent harm. Now, that goes against the interview she gave with the police, where she thought he could get out, and she went up to sleep, and she fell asleep, that she didn't mean for anything to happen. So she's going to have to call herself a liar there and say, well, actually, I was terrified of him, and I didn't want to tell you that because I thought I'd be in trouble. I thought it would be better just to say it was an accident. And she can do that, but then she admits that she just lies all the time. So, of course, I don't believe it. I think she was telling the truth on the video, that those guys were giving it to each other at certain times, and she liked what was happening to him in the suitcase, that he was restrained, and she went to sleep. I don't know that she meant to kill him by reckless conduct, perhaps. anyway, that's the idea there for battered spouse syndrome. It's not some separate defense really in Florida. It's used to establish part one of the normal self-defense claim, which is whether you were in reasonable fear of imminent threat of harm. So that's what that is. Now, if her expert only gives hypothetical examples and talks about the syndrome in general, the state expert can do that. But if she talks to this Dr. Clown and the Dr. Clown tries to show how she experienced the syndrome at that part, then the state can actually have its expert talk to Sarah and do the same evaluation, because otherwise she would be kind of sneaking around the not testifying part to let her expert say what she said. And so if she's going to do that, then the state has the ability to put her under that kind of exam as well. So all of that takes time, right? And it ain't going to happen by Monday. So this case gets put off if it hasn't already at the time we're talking about it. And now I'm going to look at the comments and see if anybody has said, yep, it got delayed already. Not yet. So we'll see maybe by the time we finish this. So that's the defense. The defense is self-defense, and battered spouse syndrome is just a way to establish the mental aspect of that, the reasonable fear. You still have to deal with the proportional aspect, but that's not really what's at issue here right now, because you need the clown to come in and say that she was afraid for her life at the time she left him in the suitcase. All right. We did that one, so we got ahead. I think Taylor Schabusiness' hearing is today too, or she has the remainder of a hearing and then jury selection. Oh, yeah. Are we going to get a trial started? Let's see. I think some trials starting on time has spoiled people to think that happens a lot. Let's see what's up here. So if I read the docket correctly, she has an evidentiary hearing this morning, and I don't have the documents. I just have the docket. So what went on was her attorneys asked for another competency hearing, and they had a doctor testify that that she's not competent to stand trial based on this doctor's opinion. And I think the state's expert had not rebutted that at that point. So if I'm right, that's what the judge is receiving this morning, because I don't think the judge has ruled on this latest competency motion, but had ruled in the past that she was competent. So I don't know that they're going to be able to convince him to delay the case at this point. Having said that, there's supposed to be jury selection starting this afternoon. And if that's true, the judge really ought to go ahead and rule on this motion one way or the other, right? Because if you're going to grant it, you don't want to be seating jurors, because you're going to have to put the trial off because she won't be competent. She'll have to undergo treatment until she's found to be competent to stand trial. She doesn't go free. She just gets treatment until she's mentally there enough to participate in the trial. That happened to Lori Vallow, where she was found incompetent for a period of time. Then when they said, okay, she can do it, then they put her back on trial. And that is separate from whether you were insane at the time that you committed the crime. They can be connected, but they are different things. You could just go bonkers while you're in prison, for example, and not be able to attend trial. So if the judge grants this, then they're going to put the trial off. But if the judge says, okay, I listened to everybody, I think she's still competent, then it's jury selection today. In this case, actually will go forward. So Sarah Boone, I think, is, of course, absolutely delayed. This one, just going to have to see what this judge will do. And since he's denied the motion once, maybe he's going to do it again. So we'll see what happens there. It's not the end of the world if it gets delayed. Your trial just gets put off. The victim in this case, of course, the actual victim, is not on in the earthly realm anymore. So it doesn't impact like it does in some of the other cases. So let's go to the pole vault. And that is the juvenile questioning question that we put up there, which was a pretty confusing hypothetical to write and therefore probably to read it and try and answer it. And it dealt with two situations that I wanted to cover. And so I put the twins there, Aaron and Ben. And in Aaron's case, you had a kid who was being questioned by police in the kid's home with his parents present. And then you had who didn't really want to talk, but his mother told him to. And then you had a kid in custody being read his Miranda rights, who was willing to talk, but also wanted his mom there. And the police said, nah, just keep talking. And he did. So the question is are these statements going to come in against these kids or not? And I put at the bottom, if you got that far, and if you don't, I don't blame you, but that is that this would be limited to federal constitutional claims only and not statutory claims or state case or statutes, because those are different everywhere. Now, they do matter, though. They matter a lot. So let's see what you guys said, and we'll talk about why this question is so crazy. So 39% of you said, yeah, they're both out. And only 11% of you say they could be admitted. And at least as I wrote the question, that's the group that I'm in. And then 35% said Aaron's allowed. That's where he was at home with his parents, but Ben's is suppressed. And he had 11% don't know, and 4% said, well, we'll throw Aaron's out, but we'll allow Ben's, probably because of the reading of the Miranda rights. But almost 80% of you said at least one of these statements is out. Now, in real life, you're right, okay, because of the things I put out of the hypothetical, which is the statutes and case law and stuff about questioning juveniles. But let's go over the Constitution and see what's up. So when you're questioning juveniles, there's no constitutional prohibition about that. And I'm still leaving this little blurb here on the right about the member stream, because we went over Miranda in a many contexts, including juveniles. So in the 11% group who said they're both there, if you're channeling how I was writing the question, I hope you're in that group with me if you were members, because we went over this. No constitutional right for a parent or guardian to be present during questioning. And statements must be voluntary, though. You can't have an involuntary statement. It's kind of like you're holding them to the adult standard. Miranda rights apply. So if it's custodial interrogation, you have to read the Miranda rights and get a knowing, voluntary, intelligent waiver. But as I said, federal statutes, if it's a federal situation, and state laws vastly adjust this. But at the federal constitutional level, the kids aren't really getting more protection than the adults. There was a case that came out of North Carolina here that went to the Supreme Court where it was a question whether the kid was in custody or not when he was being questioned at school, and there was a school resource officer involved. And that's when the Supreme Court said you have to take age in as a factor to determine whether it's in custody or not. But if you're not in custody, they don't have to do the Miranda and all that stuff. So the first hypothetical, Aaron, was based on this case, 147 F. 3rd, 1240. And in that case, that real life case, there was a 13-year-old who didn't really want to talk to the police, wasn't saying anything. They actually read him his rights at his home. And the kid didn't talk after that. When he started telling some of the story, but then when he got to the part about where the crime occurred, he goes, I don't want to talk about it anymore. The police didn't question him anymore, but that's when the mother intervened and said, you need to talk to the police, tell them the truth. That's the only way you'll heal. Take responsibility for what you're doing. And then he told the police that he did it. So the Court of Appeal said this was not a custodial situation, that a reasonable 13-year-old would not think he was in custody of the police at that point. He knew he was being questioned by the police, but he knew he wasn't in custody. And in fact, they told him, I didn't write this on here, you're not in custody. But they did read him his rights. And the court said, listen, just reading your rights to somebody who's not in custody doesn't make them in custody. And maybe that's a bonus point you get or something like that. So they said there's no waiver issue here, because one of the defense arguments was he didn't make a knowing, voluntary, intelligent waiver of his Miranda rights. And the court said, but we don't have to look at that because he wasn't in custody, and the fact that he was read his rights doesn't put him in custody. So that's interesting. And then there was the issue of, well, but was it a voluntary confession? Because no matter whether Miranda applies or not, it's still got to be a voluntary statement. You can't break out the fire hose before Miranda, start beating a person. It has to be a voluntary statement. And the court said that in terms of finding coercion to get the statement, you have to have police action, and a parent cajoling the person to talk to the police when they weren't asked to do that by the police or encouraged by law enforcement or whatever. That does not represent police overreach. So it's not part of considering whether the government did something to cause an involuntary situation. And he didn't clearly invoke his right to silence. He just stopped talking, and then the mother intervened, and then he started talking. So in that case, they said, yes, the statement can come in. Now, note I put on here, defense bar disagrees, because when I was making these slides, I hadn't seen this when I made my hypothetical. I found this hypothetical, which was for a defense attorney conference in North Carolina. I don't go to those, but here's what they talk about when they're together. Look at their hypothetical. Officers suspect your client, 15-year-old boy with no history in court, because that's a factor, involved in a break-in. They interview him at his house. His mother invites him in, and they're not uniform or armed or whatever. And they say the interview is voluntary, and they ask the defense attorneys who are all gathered up in this room to talk about strategies to help your clients, which is what they should do. Is the juvenile in custody? And they don't give a concrete answer on their slides. They talk about the kind of factors that we've talked about, whether a reasonable person in that situation would think they were, and what are the factors and all of that. And defense attorneys will say, well, actually being questioned in your home is more like custody because you have nowhere to retreat to out of there if you did want to leave it. So a lot of thinking goes into this. I mean, the courts, I'm not saying buy that, but you try and think of every angle you can on behalf of your clients, and that's an angle. And then the rest of their hypothetical was they began questioning the client about the break-in, blah, blah, blah. Yeah, okay, so here's where the mother says, hey, you better man up and tell the truth. Is the confession voluntary? Now, in that case I showed you from the 10th Circuit, it was found to be voluntary. But not every Miranda case or voluntary confession case goes to the Supreme Court. So it all depends on what judge you're in front of and the Court of Appeals that you go to. If you do, in terms of how somebody assesses what happened in that situation, the totality of circumstances of whether the person was voluntary or not. All right, so in custody, you have to make a knowing, voluntary, intelligent waiver. They're talking about Ben now. And a hypothetical assumes that. But that can be a big issue. So if you stop there and you said, oh, I don't think it was a knowing, voluntary waiver, can't count you wrong there. I assumed it in a hypothetical, but you could expect a defense attorney to challenge that. Now, he asked for his parent. No constitutional right to a parent presence. And I had seen another case where the guy asked for his parole officer, and they said, nah, it's not happening. Just keep talking. But you still have to have the statement be voluntary in the totality of circumstances. And if you don't have a parent present, the court can consider that as one factor. So here, my vote would be this is still a voluntary statement because you don't have a right for the mother and there's no real pressure there. You might see that differently, so I understand that if you do. But the statement would not be thrown out on the basis he had some right to have his mother there. It would have to be on the basis the court said, well, he did ask for her, and it was a gray room and the door was shut. And you have to, one light bulb swinging. You'd have to come to a conclusion that it was an involuntary confession, not anything to do 100% with whether his parent was present or not based on his request. All right. Juvenile Miranda. I did say at the beginning, for the vast majority of people who said this should be thrown out, that you're not wrong in real life because many states, and I'm going to show the North Carolina statute here, and the federal government have created kind of what's called juvenile Miranda rights. Let's look at what North Carolina has. It's probably typical of a lot of states, but they're all different. They're all different. So here, a juvenile in custody must be advised they have a right to remain silent, that what they say can and may be used against the juvenile in court, that the juvenile has a right to have a parent, guardian, or custodian present, and the right to consult with an attorney. So they put in this juvenile Miranda that you have to tell the kid they have a right to have a parent there. Our state puts that equal there with the right to remain silent and asking for an attorney. And then note the second part. So the juvenile could say, no thanks. Let me talk to you. I don't want my parents here. Let me just tell you what I did. And that's okay, except when you get to subsection B, if the kid is less than 16 years old, you cannot have an in-custody admission or confession into evidence unless there was a parent, guardian, custodian, or attorney there. So the waiver in North Carolina does not, you can't get one for a parent under 16. You can for the other rights, but if they're under 16, you got to have the parent there if you want to use anything against them. So it's pretty strict, right? So for people who thought that, hey, the parent has a right to be there, there often is this right, but it was created by states largely where they do have them because the federal government on a constitutional level doesn't have such a right as that. So whatever your state says governs kind of in this situation. All right, so let me check out what the comments are. Somebody said go to Sarah Boone in court. Well, I don't have anything queued up for that because I didn't find where they streamed that directly, but there could be a news site doing that. So about 1 hour from now, I'm going to queue up the Daryl Brooks hearing, and the judge will stream it. And I'll start it a little bit early to go over the charges and status of that case. So maybe I'll see some of you guys there at that point. Somebody said that he did have Sarah Boone on Court TV. So yeah, I'm going to try and catch that as soon as I get out of this, like you guys probably will, and see what the result was. And I have to delete this video if it wasn't delayed, but I'm sure that they have another conference set up or something like that. So I think that's it. I'll go check that out, and then I'll watch this Daryl Brooks case at 10:45 my time. The stream of the court should start at 11. We'll just go over what the status is a little bit before that. All right. Thanks, everybody, for coming by. And for those who aren't going to tune in later, have a good weekend. And for those that are, I'll catch you guys later. That's it for this. Thanks. Bye.